Hi guys, how are you? What's up? I hope you all are doing very amazing. Welcome back to our day 7 of our CMA Final Law Marathon lectures. People, today's chapter is very important. The name of the chapter is Director and KMP. The most important chapter, guys, Directors and KMP. In every attempt, if you observe, questions were asked from this chapter for 7 marks. And this lecture is going to be a very lengthy lecture, but trust me guys, just by watching this lecture of 2.5 hours to 3 hours, you can easily fetch 7 marks for your exam. Okay, chalo, shall we get started guys? First, quickly tell me, is my voice audible? Is the screen visible? Whoever is watching my lecture right now, quickly tell me no. Is my voice audible? Is my screen visible? Perfect. Chalo guys, let's start. We're going to revise from the mind maps, and in the link, in the description link below, you will find one WhatsApp group. Go to that WhatsApp group. In that WhatsApp group, in the description, you will find one Google Drive link. I'll tell you clearly how to find my notes. Simple. Number 1, go to description, join WhatsApp group. In the description of WhatsApp group, you will find one link, Google Drive link. In that Google Drive link, you will find all my notes along with my mind maps. Okay guys, so print my mind maps, revise it before the exams, and you see the difference, how beautifully you score in CMA Final Law exam. Okay, chalo. Now we are not going to waste any time. Let's quickly get started. The first topic is guys, board composition. Board composition. Chalo, let's begin guys. Number 1, only individual human beings can be directors. Company, firms, other entities cannot become a director. If I talk about public company, minimum 3 directors, private company minimum 2 directors, OPC minimum 1 director. We all know this, very basic. Okay. Now, maximum directors, 15. Can you increase your number of directors more than 15? Answer is yes, by passing a special resolution. For government company, section company, SR is not applicable. Okay. Number of directorship held by one person. One person can become a director in maximum how many companies? Maximum 20 companies he can become a director. Out of that, if he is a director in public companies also there is a limit. Maximum he can be a director in 10 public companies. Remaining he can become a director, but 20 companies is the maximum limit. If I talk about all the companies, but if you want to become a director, then maximum you can be a director in 10 public companies, not more than that. If you are director in 11 public companies, you have violated the law. Easy guys. Okay. Minimum director strength and validity of decisions. So guys, we all have learned yesterday in section 174, we have learned quorum. So if number of directors falls below minimum number, all the board of decisions will be completely void. If AOA requires higher quorum, you have to follow the higher quorum limit. AOA can be stricter compared to Companies Act, and you have to follow AOA provisions. Okay. One more thing guys, yesterday also I told you, if AOA is lenient compared to Companies Act, you have to follow Companies Act. If AOA is stricter compared to Companies Act, you have to follow AOA. Whichever is stricter, you have to follow that only. Very easy till here. If you have got any doubts, please let me know in the chat box. if you are the student who is watching this lecture after live has ended, please make sure to drop all your doubts in the comment section. Okay, I will also fix one timer so I can drink water on time. Chalo guys, next is first director. So guys, if a company is incorporated and no provision is there in the articles of association with respect to appointment of directors, subscribers to the memorandum will become the first directors. Company has been incorporated. In the AOA, nothing has been written with respect to who can be first directors. In that case, guys, subscribers to the memorandum can become first directors. Guys, I hope my voice is audible. Perfect. Chalo guys, next is this first director provision is applies to public company, private company. OPC sole member deemed to be the first director. We all know this. Okay. What is the meaning of first director? Initial director who is responsible to start the company's operation until the final appointments are made. So we all know guys, final appointments are made by shareholders in the annual general meeting. So once a company has been incorporated till the annual general meeting, we need someone to manage the company very well. Those someone is called as first directors. Easy guys. Chalo. Now let's talk about section 149 subsection 3 that talks about resident directors. Resident directors. Now guys, any company incorporated in India, we require resident Indian directors so we can make somebody else responsible. Yes or no guys? So purpose is ensuring company has got at least one director physically who is present in India, so he can hold the legal position and operational accountability of the company. So company is doing some fraud. Whom are we going to catch if there is no resident director in India? Are you able to understand guys? So purpose is company shall have one resident Indian director who is present in India physically, so we can hold them accountable with respect to legal and operational. Okay. Now, every company requires at least one director who has stayed in India for equal to or more than 182 days in the financial year. Very, very important. In your MCQ, question can be asked. So, every company requires one director who has stayed in India for a period of 182 days or more in the financial year. Okay. Now guys, this one is very, very important rule. You will often get confused when you read this rule. If a company has been newly incorporated, 182 days requirement applies proportionately for the year of incorporation. Sir, I did not understand anything. We all know that every company requires one director who is a resident in India physically for equal to or more than 182 days. But if the company has been incorporated newly, only 3 months has lapsed since the company has been incorporated, how can the 182 days limit will be followed? Yes or no guys? So in that case, law says proportionately it will be applicable. Let's read the example. Company has been incorporated on 1st October 2024. Remaining days in the financial year is 182 days. In that case, guys, only 91 days will be applicable. Okay, so basically, guys, the law says out of 365 days, 182 days, director shall be resident in India. That means half of the year he shall be resident in India. Now, the remaining period is 182 days. In that case, only 91 days is applicable, not 182 days. Okay. Example number 2. Company incorporated on 1st January 2025. Remaining days to for the financial year to get over is 90 days. In that case, 45 days will be applicable. So whatever days are remaining for the financial year to get over, you take the remaining days and divide it by 2. Simple. Another example. Company incorporated on 1st Feb 2025. Remaining days 59 days. Required stays 30 days. So simple guys, you take the remaining days for the financial year to get over and divide it by 2. That is the number of days the director shall be resident in India physically. Very easy till here. Hi Jayanand. Okay, now let's talk about woman director, section 149 subsection 1. Don't get scared about how do I remember sections. I'm going to make sure that I'm going to take 1 lecture or 2 lecture maximum. After that lecture, you will not have any difficulty in remembering sections. That is my promise. Sir, how is it possible? Are you going to teach like a conventional method like everyone does? No. We are not going to memorize it. We are going to use a magician's trick. Have you ever observed how a magician is able to remember so many numbers easily? We are going to learn that magician trick to remember so many numbers very easily. Okay guys, don't worry. I have read one book that talks about how magicians remember numbers. I'm going to teach you that trick. Very easily, effortlessly, you will be able to remember all the sections. Don't worry. Okay. Now let's talk about woman director. So, the law says they have to appoint 1 woman director. Now, who have to appoint? Which companies have to appoint 1 woman director? Let's understand. Top 1000 listed companies based on market cap have to appoint 1 woman director. Top 1000 listed companies have to appoint 1 woman director. Public companies whose paid up capital is 100 crores or more or turnover is 300 crores or more, those public companies have to appoint 1 woman director. Again, tell me guys, paid up capital 100 crores or more, turnover 300 crores or more. If it's a listed company, you have to check whether it is coming under 1000 top listed companies. If the answer is yes, they have to appoint 1 woman director. Very easy guys. Very important question will come in your exam. People also, if you go through my notes, I have marked clearly what questions have come in your PYQ, what questions have been added to your model question paper, what questions have been included in the module. Please go through that guys, very important. Okay, chalo. So if a company has been newly incorporated, they have got 180 days to comply with the appointment of woman director. Okay. Now if there has been vacancy in the woman director, there is a vacancy in the woman director. In that case, within how many days we have to fill that vacancy guys? Less than immediately the next board meeting or 3 months from the vacancy, whichever is later. So within the next board meeting you have to appoint, or within 3 months from the vacancy, whichever is later, you have to appoint and fill that casual vacancy. Okay. Next is guys, independent director, section 149 subsection 4. Very important guys. Every attempt this question has come in your MCQ. Okay, chalo. Let's read this guys. Independent director, don't get scared by looking at the mind map. It is very easy. Just be with me. Independent directors. Why do we appoint independent director? So independent directors are those who are not associated with the company in any way. Now the important question is, why do we appoint independent director? So they can give an objective judgment. They will not get emotional with the company. Obviously guys, often when we take emotional decisions, those decisions end up being bad. So that case guys, that is why it is required for a company to appoint an independent director, so that they can give objective judgment, ensure compliance and protect the shareholders' interest and not the promoters. So they shall be a non-executive director. They shall not be the executive who works with the company continuously. He shall not be an MD. He shall not be a whole-time director. He shall not be a nominee director. he shall not have any material or pecuniary relationship with the company, promoter or director. What is the meaning of pecuniary, guys? Any monetary relationship independent director shall not have with the company, promoter and the director. Okay, sir. Guys, every 10 minutes I'm going to drink water. Chalo. Now, we know the meaning of independent director. We know who can be and who cannot be independent director. Now, to which companies independent director is applicable, we are going to understand. First of all listed companies have to appoint independent director. At least 1/3 of total number of directors shall be independent director. So, every listed company, I'm not talking about top 1000, top 500, no. All the listed companies have to appoint independent director. 1/3 of total directors shall be independent. 33.33% of all the directors shall be independent directors. Okay, if we talk about unlisted public companies, paid up capital 10 CR, turnover 100 CR, outstanding loans, borrowings, deposits 50 CR. They have to appoint at least 2 independent director. Guys, again tell me quickly, same like audit committee applicability. Paid up capital 10 CR, turnover 100 CR, outstanding loans, borrowings 50 CR. They have to appoint independent director. How many? At least 2 independent directors. But if we talk about top 1000 listed companies, they have to appoint 1/3 of total directors as independent director. All listed companies, guys, all listed companies have to appoint 1/3 of total number of directors as independent directors. Okay, sir. Next is exclusions for unlisted public companies. To these companies, this rule will not be applicable. Joint ventures, wholly owned subsidiary, dormant company. To these companies, the independent director appointment is not applicable. Okay, sir. Now, talking about the term of appointment. So, maximum term of independent director is 5 consecutive years, guys. He can be reappointed by special resolution, and in the board report, disclosure has to be made. Okay, sir. Cooling off period. Once his term has ended, after 2 consecutive terms, he has to wait for 3 years to get reappointed. And in these 3 years, he shall not be associated with the company in any way. So we know, guys, 1 term means 5 years. He can be an independent director for 2 terms. After 2 consecutive terms, he cannot be associated with the company in any manner for how many years? For 3 years. Okay, sir. Appointment for less than 5 years will be called as 1 term. Retirement by rotation will not be applicable for independent director. We're going to understand what is the meaning of retirement by rotation. Okay. Now, liability. Independent director and non-executive director shall be liable only for the acts committed that was when they were director in their tenure. Knowledge, consent, connivance, or fail to act diligently. So, independent director and non-executive director will be liable only for the acts committed where they had the knowledge, where they gave the consent, where there was connivance, or fail to act diligently. What is the meaning of connivance? They could have stopped it, but they did not. That is called as connivance. They will be held responsible. Okay. All the independent directors of the company must hold at least 1 meeting annually where non-independent directors are not present. All the independent directors have to conduct 1 board meeting every year where there is no non-independent director. Everyone should be independent director. Okay, sir. Now. Remuneration. Let's talk about remuneration. independent director cannot receive stock options, obviously. He can receive fees for attending the board meeting and committee meetings. He can be reimbursed with the expenses. And last is profit related commission. So company can give him a commission based on the profit the company has earned. Completely all of we are going to understand exactly how the profits can be distributed as commission. If the company has got no profits, then how will the independent director will be paid? ID will be paid remuneration under Schedule 5, where limits are set under Companies Act. Okay. Excludes fees payable under Section 197. Sitting fees is additional. Okay. Now, guys, let's talk about exemptions. So, to these companies, independent director provision will not be applicable. Section 8 company, IFSC company, exemption applies to all the provisions with respect to requirement of ID, definition of ID, remuneration of ID. So to these companies, this law will not be applicable. Till here, guys, very, very easy. Jayanand is asking, okay, so you have a very valid doubt, guys. We'll teach you the difference between listed company and a public company. Guys, listen to me very, very carefully, okay? Private, public, listed. I want my company to be held by my family members only. My family members are less than 200. I don't wish to transfer shares. I don't wish to accept money from the public. I want my company to be completely private. So I will incorporate a private limited company. Now, shareholders, I want to invite more shareholders in my company. Now, the number exceeds more than 200. Number goes to 201, 300 or 350. In that case, guys, I will convert my private company to public company. This is the difference between a private and a public. Now, I wish to get myself listed on the stock exchange. Public companies are not listed on stock exchange. But if public company wants to get listed on the stock exchange so that I can enjoy credibility in the market, I want more money in thousands of crores, in that case, I will list my shares on the stock exchange, for which I have to follow SEBI rules and regulations. Then I will become a listed company. I want to raise thousands of crores of money. I want my shares to be listed on stock exchange. I want to enjoy credibility. I want to become famous. In that case, I will list my shares on stock exchange. If simply I've got more than 200 shareholders, I want small amount of money from the public, I don't want to follow SEBI rules and regulations, then I will keep myself a public company. Are you able to understand the difference between a private company, public company and a listed company? All listed companies are private companies. All listed companies are public companies. All listed companies are public companies, but not all public companies are listed companies. Are you able to understand? Jayanand, give me a quick thumbs up. Chalo guys, I will proceed forward. Janan, quickly give me thumbs up. All public companies are not listed companies, but all listed companies are public companies. Are you able to understand? Perfect. Chalo. Now, the moment independent director is going to get appointed, they have to declare that they are independent at the first board meeting, at first board meeting of every financial year. Whenever circumstances change that may affect his independence. So, the moment I am appointed as the independent director of Reliance, immediately in the next board meeting, I have to declare that I am independent, number one. Okay. Every year also in the first board meeting, I have to declare that I am independent. And number three, if company is transacting with any person, now that person might be my best friend, might not be my best friend, but there's a possibility in that case also, wherever independence criteria can be affected, I have to declare that I am independent. Very easy, guys. Okay. Next is, if no situation exists affecting independence, board officially record and verify the declaration. Guys, this is not important, okay? Just note this one down. It is very, very important. When is independent director supposed to declare that he is independent? Okay. Now, special cases. If audit committee requires that company requires more independent directors, company will have to appoint higher number. Section 8 company plus IFSC, they don't require. Vacancy of independent director, it has to be filled in the next board meeting or 3 months, whichever is it is, same like woman director. Company, if they ceases to meet criteria for 3 consecutive years, that means what? We know to which companies ID is applicable. Now company in the next 3 years, they have not touched the threshold. In that case, guys, after 3 years are over, company is then not required to appoint ID. Example is, year 1, they have touched the threshold, they have to appoint ID. Year 2, year 3, year 4, they have not touched the thresholds, but for 3 years, ID will be there in the company. Once the company does not meet the threshold limit for 3 years consecutive, from year 5 onwards, ID will not be required. Very easy, guys. Chalo. Now let's move on to eligibility criteria. Section 149, subsection 6. So, independent director shall be a person with integrity and expertise. He shall do the right thing even when nobody is watching. He shall not be a promoter, or he shall not be associated with the promoter of the company also, of its associate company also, of its holding company also, of its subsidiary company also. So ID shall not be a promoter, ID shall not be a relative of the promoter of the company, its holding company, its associate company, its subsidiary company. Very easy. Skill requirements, finance, law, management, marketing, others as required by the company, ID must possess the required skills. Okay. Now let's talk about pecuniary independence. That means what? Monetary independence. There shall not be any financial relationship beyond the director's remuneration, transactions less than 10% of total income. Previous 2 years, current year. What is the meaning of this? So ID can receive money from the company, provided it is less than 10% of his total income, number one. Provided that money is a director's remuneration, no problem. 2 things I have told you. Director can have monetary transaction with the company less than 10% of his total income, number one, or he can receive money as a director's remuneration, no problem. Now guys, previous 2 years, current year will be considered. So basically 3 years period will be considered. Easy guys. So this two conditions shall be followed for this year also, for the last 2 years also. If this year plus last 2 years, these conditions were followed, then only he can become an independent director. Are you able to understand guys? Give me a quick thumbs up everyone. Okay. Next is guys, non-profit organization restrictions. So, independent director cannot be a CEO or the director of an NPO. How come? So, company is different. Section 8 company is different. Now, company, Section 8 company receives, let's say, 100 crores donation every year. Now, out of 100 crores, 25 crores is given by this company, and this person is a CEO or director of Section 8 company. In that case, this guy cannot become the ID of this company. Very easy. Are you able to understand guys? Is my speed comfortable? Let me know. Give me a quick thumbs up if my speed is comfortable. If you want me to slow it down, I will slow it down guys. But please make sure that you are able to understand every single thing. Okay? Any doubt you have got, please let me know in the chat box. Okay. So first condition is, cannot be a CEO or director of the NPO that receives 25% or more from the company. Rule number 1. Or he holds 2% voting power in this Section 8 company, he cannot become a independent director of this company. Jayanam, listen to me very, very carefully. ABC Limited, XYZ. It's a Section 8 company. Okay, you know the meaning of Section 8 company? Charitable purpose. This Section 8 company receives donation worth 100 crores. ABC Limited donates 25 crores to XYZ. It's a significant portion. Into 25% is 25 crores. Now, A is a director or CEO of Section 8 company. A is a director or CEO of Section 8 company. What the law is trying to tell you is, this person cannot become ID of ABC Limited. Are you able to understand now? This person cannot become independent director of ABC Limited, because if he becomes the ID of ABC Limited, he will try to take decisions that will favor Section 8 company, obviously. So, can we call him as independent? No. This is rule number 1. Rule number 2 says, this person cannot hold 2% or more shares in Section 8 company, not allowed. If he is holding, then he cannot become ID of ABC Limited. That is what I am trying to tell you. Okay? Sure. Next is employment restrictions. Independent director shall not be a director, or his relative shall not be a director. He cannot be an employee. He cannot be a KMP. He cannot be a proprietor. He cannot provide professional services to the company in the last 3 years. Otherwise, we cannot call him as independent. He cannot be the auditor, he cannot be the CS, he cannot be the cost auditor, he cannot provide legal consultancy services in the last 3 years to the company. Easy guys, till here, he or his relatives cannot engage in such type of transaction with the company. If they have entered into such transaction, this person cannot simply become ID of this company. That's it. Okay? Jayanand, if I'm holding shares in Section 8 company, I cannot become the ID of that company that donates 25% or more money to the Section 8 company. Always remember this. Okay guys, so I will proceed forward. Now over here, if the relatives are employed in the company, there is no restriction. For example, if my brother, I want to become the ID of Reliance, before I become the ID of Reliance, my brother 2 years back, he already became the employee of Reliance. Under normal circumstances, there was no favor, it was purely coincidence. In that case, nobody can stop me from becoming ID of Reliance because my brother was appointed in a normal manner in Reliance. Okay. If my brother is appointed in a normal job, it is completely fine. But if he is a KMP promoter director, then I cannot become the ID of Reliance. Always remember this, guys. Wherever there's a small possibility that my independence can be affected, I cannot become the ID of the company. Jayanand, what we'll do is, once this lecture gets over, please drop all your doubts in the comment section. I will ensure that your doubts will be cleared. Okay, Jayanand? What will happen is, if I start clearing doubts from Jayanand, it will take 4 or 5 hours to get this revision lecture to get over. Okay? So whatever important doubts you have got in Jayanand, I will make sure that those doubts are cleared in the class. But whatever doubts are small doubts, which requires very big explanation example, I will make sure that I will explain this in the comment section in a very simple language. Okay? Chalo. Now guys, this one is very important. Relative restrictions on himself. So, relatives and independent director cannot hold shares or securities in holding company, associate company, subsidiary company for 50 lakhs or more, or 2% or more of the paid up share capital, whichever is less. We all know this. You have to simply learn these limits, guys. Relatives or ID shall not be indebted. They are not supposed to give money to the company. Hi guys. तुम्हारा क्या लेक्चर चल रहा है? Oh, okay, चलेगा, done. Yes, guys. So, ID shall not be indebted to the holding company, Section 8 holding company, subsidiary company, associate company for 50 lakhs or more. Third is, ID shall not have provided, or ID's relative shall not have provided guarantee to holding, subsidiary, associate for 50 lakhs rupees or more. If the answer is yes, they cannot become the ID. If the ID is holding pecuniary transaction, will the holding, associate, subsidiary for 2% or more gross turnover total income of the company, he cannot become the ID. Simple, guys. If the ID along with their relatives, if they are holding pecuniary means monetary transactions with the holding company, associate company, subsidiary company. Now there is a limit that says 2% or more gross turnover of the company or the total income in the previous 2 years or current years. So 3 years will be calculated for all these conditions, guys. Okay? Again, I will tell you guys, ID along with the relatives cannot hold shares, securities in the holding company, associate company, in the subsidiary company for 50 lakh rupees or more, or 2% of the paid up share capital, whichever is less. Number one. Number two is ID along with the relatives shall not be indebted to the company, holding, subsidiary, associate, 50 lakh rupees or more. ID along with the relatives this year as well as last 2 years should not have provided guarantee to holding subsidiary associate for 50 lakh rupees or more, and there should not be any pecuniary transaction with holding subsidiary associate 2% or more of the gross turnover or total income. Okay, chalo guys. That's it. Now next is independent directors and committee. Let's read this. So guys, if I talk about audit committee, just zoom in, zoom in, zoom in. Yes. So if I talk about audit committee, guys, minimum 3 directors shall be there. Independent directors shall be majority or all, because audit committee is very sensitive committee. Next is NR committee, minimum 3 non-executive director, at least half should be independent director. CSR committee, minimum 3 directors, at least 1 shall be independent director. Always remember guys, the more there's a risk, the more there's a requirement of independent director. Always remember that guys. Okay. Now if you want to pay sitting fees or commission, how are you going to pay? Independent directors are entitled to sitting fees. Sir, what is the meaning of sitting fees? Sitting fees means fees paid to participate in the board meeting, to give their opinions, to give their suggestions. It should not exceed 1 lakh rupees per meeting. Reimbursement of expenses can be allowed. Commission with respect to profits. So maximum 1% of net profit if the company has got whole-time director, managing director, manager. 3% of net profits in other cases. No stock option is allowed. We all know this. If profits are inadequate, company cannot pay money to the ID. Company can still pay money following the limits of Schedule 5. Okay. That's it guys. Now let's talk about section 151. Let's take a break of guys 5 minutes. We'll meet at 6:01 p.m. Yes, guys. Chalo. Shall we begin? Shall we begin? Shall we begin? So, guys, our next topic is small shareholder director, section 151. Now, guys, exactly what is the meaning of small shareholder director? Any shareholder who is holding shares worth less than 20,000 rupees is called as small shareholder director. Equity shares or preference shares, both will be counted. Okay. Now, let's talk about tenure of small shareholder director. So, maximum he can hold his small shareholder directorship for 3 consecutive years. Small shareholder director is not liable to retire by rotation, not eligible for reappointment. Okay. Next is limit on number of directorship held by a small shareholder director. So if I am a small shareholder director, I can be maximum director in 2 companies. And the condition is those 2 companies shall not be in a competing business. Those 2 companies shall not be competitors. Okay, sir. Now, small shareholder director is considered independent as per section 149 subsection 6. Same, the independent director criteria will be applicable to small shareholder director also. He gives declaration of independence in as per section 149 subsection 7. He shall be an independent person. Okay, sir. Now, restriction post cessation of small shareholder director. Once my tenure got over, I shall not be associated with the company for the next 3 years in any capacity. Okay, sir. Statement by proposed director. So, if I am a small shareholder director, I want to become a SSD of Reliance. SSD means small shareholder director. If I want to become SSD of Reliance, I should give my DIN. I shall declare that I am not disqualified. We are going to understand section 164. I consent to act as a director. Okay. Next is notice of intention to propose a candidate. So if shareholder of a company, before the annual general meeting of the shareholders, if they want to appoint me as the small shareholder director, how are they going to propose? They must submit a signed notice 14 days before the annual general meeting that I want to appoint Balgopal Sridharan as the small shareholder director. Include shareholding details and proposed director details, name, address, shares and folio number. Basically, all the details the shareholder has to disclose to the company before 14 days. Okay. Now, election of director. A listed company can elect SSD. Listed company can make me as the SSD. How? If notice is given by at least 1,000 small shareholders or 1/10 of total small shareholder. Over here I am talking about the number. Over here I am talking about 1,000 small shareholder or 1/10 of total number. Let's say 10,000 small shareholders are there. 1,000, okay, we will call this as 12,000. 12,000 small shareholders are there. 1,000 or 1,200, whichever is less. If the notice is given by these people, listed company can elect me as the small shareholder director. Simple, guys. 1,000 SSH or 10% of SSH. If they give notice, I can be appointed as the SSD. Okay. Voluntary appointment. So even if notice is not being given by any person, still the listed company can voluntarily appoint a director without any notice. Okay, sir. That's it. Vacation of office. How will the office be vacated of a small shareholder director? Ceases to be SSD. incurs in disqualification of section 164, ceases to be independent, office is vacated for some other reason. Okay. Now additional note, SSD can be removed simply by passing an ordinary resolution in the general meeting. Very easy to remove SSD, just pass over. That's it guys. So we are done with SSD. If an exam question has come, you should be able to answer them. Very easy guys. After this marathon lecture gets over, simply learn from my mind maps, you will be sorted. Every single topic has been covered in the mind map. Not even one thing is left. Okay guys, chalo. Now, section 152 that talks about appointment of director. So, before director is appointed, he has to obtain a DIN. What is the meaning of DIN? Like you and I have got PAN number, Aadhaar number. All the directors of any company, they have got DIN number. So they have to furnish DIN before, they have to furnish DIN and declare that they are eligible to become a director before they are appointed. They have to also submit a written consent. Now written consent is in which form? Form DR2. They have to submit a written consent to become a director of the company. Now, so director has submitted his DIN. Director has given his declaration. Director has also given his consent in DR2. Now, company, once they appoint a director, within 30 days, they have to inform to ROC that we have appointed a director. In which form? In form DIR12. Okay. Now, if I talk about first director appointment, if articles contain provision with respect to directions, you have to follow articles. If nothing is been included in the articles, then individual subscribers will become the first directors. We know this. Okay. Now subsequent directors, I'm not talking about first directors. First is done. Now subsequent directors, appointment in general meeting unless otherwise provided in the act. So basically guys, if I talk about first directors, subscribers will become, if the article is silent, subsequent directors will be appointed in the annual general meeting by the shareholders. Okay. Chalo guys. Next is rotation and non-rotation directors. Very, very important. Section 152, subsection 6, section 152, subsection 7. Now, first let's understand to which companies these provisions are applicable. To all the public companies, these provisions are applicable. Independent directors are excluded in the calculation. We are going to understand calculation over here. So whatever calculation we are going to do, independent directors will be excluded from the calculation. Just understand this. Okay. Now case 1 guys. Case 1. Articles provide that all directors are supposed to be retired. In that case, all directors are rotational directors. If articles provide that all directors shall retire, then they have to follow articles. If article is silent, in that case guys, listen to me very, very carefully. 2/3 of total directors will be rotational directors. 1/3 of total will be non-rotational directors. Supposing 9 directors are there, 2/3 of 9, 1/3 of 9. 6, 3. So 6 directors are rotational. They are non-rotational. Okay. So public companies require the director should keep on rotating continuously so they can act independently. So for that purpose, these provisions have been made. So if article is silent, 2/3 of all directors shall be rotational director, 1/3 will be non-rotational directors. Okay. Now let's talk about rotational directors. So now we know that 2/3 of all directors will be rotational directors. Now exactly who will retire among the rotational directors? 1/3 of rotational directors. So we know over here 6 directors are rotational. So 1/3 of 6 is, guys, how much? 2 directors will retire at every AGM. Okay. If AGM is not held, retiring director must vacate. That is for sure. Okay. Now if we talk about non-rotational directors, they do not retire by rotation. They hold office for the tenure specified at the time of appointment. So non-rotational director, whenever they are going to get appointed, company specifies for how long you are going to be a director. For that period only, the person can be a non-rotational director. Okay, sir. Now, filling of vacancy at AGM. If vacancy due to retirement can be filled by reappointing the retiring director, appointing another person as per section 160, putting a resolution not to fill casual vacancy. So guys, if we talk about rotational and non-rotational directors, and if a position is vacant, we need to fill that position by appointing director. Now what are the options company has got? Number one is, guys, company can appoint the retiring director as the new director. Company can appoint another person in place of the director, or company can decide that we don't want to fill the vacancy at all. Okay. Now vacancy if not filled, in the next AGM they can be filled. If in the next AGM also it cannot be filled, you know the answer. Automatic reappointment of retiring director. Very easy, guys. Till here, do you have any doubt? Let me know in the chat box. If you are watching lecture after live has ended, please let me know all your doubts in the comment section. Okay. Now, next is, guys, DIN requirement. Again, very important topic. It is very simple, but many times these questions have come in your exam. So we know the meaning of DIN. DIN is specific to a person. One person can only have one DIN. He cannot have two DIN. Like we can have only one Aadhaar number, one PAN number. So in the same way, one person can only have one DIN. If that person leaves the company, if he joins another company, still the number will be the same. If you have got a PAN number, if you shift to another country or another state, will your PAN number be changed? No. Same with the DIN number. If he accidentally obtains two DINs, you have to surrender one DIN. Okay, sir. DIN also includes DPIN. So DPIN means if you are a designated partner in an LLP, DIN and DPIN will be exactly the same. So legal mandate is every director shall provide a DIN in which he is going to become a director, declare that they are not disqualified. We know this. Okay. Application process. How are you going to apply for DIN? Electronically. Fees you are going to supposed to pay to the central government. DIN for first directors of new company. Now that I am going to incorporate a company, I don't have any DIN. Just by filing Spice Plus form, I can get my DIN number. Apply via Spice Plus. Maximum 3 directors can be allotted a DIN via Spice Plus form. Okay. Can a company issue shares without voting rights? No, Jayanand, they cannot issue. And your question, Jayanand, that can we become a shareholder of section company? Obviously, you can become a shareholder of a section company. You can hold shares of section company. There is no doubt in that. Jayanand, please tell me which point you want me to explain. Hey Siri, 10 minutes timer. Chalo guys, I'll proceed forward. Next is appointment of non-retiring directors. So we understood retiring director. Now let's understand non-retiring directors. Okay. Who can basically become a non-retiring director? Let's take an example that Reliance Industries. Jayanand, please tell me specifically which point you want me to explain. Chalo guys. So who can be appointed as a non-retiring director? Any person, member or non-member. What is the meaning of member, non-member? He can be a shareholder, he cannot be a shareholder. He can be appointed as a non-retiring director. Who is not a retiring director? So guys, simple. Two types of directors, retiring director, non-retiring. If you are retiring director, how can you be appointed as a non-retiring director? Simple logic guys. Includes additional director, casual vacancy, alternate director, nominee directors. So these people can also become non-retiring director. Okay sir. Guys, if you observe them, they all are temporary directors. They all are temporary directors. So they can also stand for directorship. Okay. Now, which companies are exempt from this provision? 100% government company, private company, Section 8 company are exempt. Now notice requirement. Again same guys, written notice to the company at least 14 days before the general meeting that I wish to be appointed as the non-retiring director in the company. Notice can be given by the candidate himself or by the shareholder who is proposing him to become a non-retiring director. Next is deposit requirement. If I want to become a non-retiring director of Reliance, it is not so easy. I have to deposit 1 lakh rupees or higher amount as may be prescribed by Reliance. So any Tom, Dick and Harry cannot become a director in a company. They have to invest money. They have to deposit 1 lakh rupees money. Now, if you are not appointed as a director, then you will not get that 1 lakh rupees money back. But there are certain situations where you can get 1 lakh rupees money back. If you get elected or if you secure 25% voting in favor, you might not have won the election to become a director, but at least if you have secured 25% or more, the money will be refunded back to you. Okay. Exemptions from deposit. Independent director or candidates recommended by NRC or board, they don't have to deposit money. So independent director, they don't have to deposit money, or candidates who are recommended by whom? NRC, Nomination Remuneration Committee or board. So over here, company is proposing to appoint. In that case, company cannot ask money from the director. Okay. Chalo guys, now what is the procedure? Refund deposit if applicable, you have to file DR12 form. I told you if you are going to be appointed as a director, you have to file DR12 with the ROC within how many days? Within 30 days. If it's a listed company, they have to forward proceedings with the stock exchange. They have to update registers. They have to inform company where this person is already a director. So if I am already a director in many companies, I have also become a director in this company, I also have to inform to all the companies. Simple logic guys. Okay. Miscellaneous is DIN requirement. Obviously, if not, you have to apply to central government. Consent and declarations you have to give. So AGM procedure proposal will be taken by over. So if 51% shareholders say that we want this guy to become a director, you can become a director. Multiple candidates. So person A, person B, person C, all three want to become a director. So separate resolution is supposed to be passed for all three. Person A, 51% vote. Person B, 60% vote. Person C, 30% vote. separate resolution have to be passed. Okay. Company must inform members 7 days before the AGM by individual notice and publish in 2 newspapers, one in English and one in regional. So, shareholders must have knowledge about this person's character, his knowledge, his experience. So, company must send notice to all the shareholders before the annual general meeting in which he is going to get appointed by the shareholder. How many days, guys? 7 days before the AGM. It could be by individual notice or it could, and they have to publish in newspapers. If I talk about listed companies, they have to inform stock exchanges. That's it, guys. Next is additional director, section 161. Jayanand, what we'll do is, let me first complete this lecture and then we'll come to your doubts. Okay, Jayanand? Please make sure that you are noting all your doubts. Definitely all your doubts will be resolved. Okay, Jayanand? Please note it down. Otherwise, just drop me a WhatsApp message personally explaining your doubt in a complete manner. Chalo. Next is, guys, additional director. So who can be appointed as an additional director? So any person except someone who failed to get elected as a director in a general meeting. So guys, we all know that if board requires that company is expanding fast, company has got a lot of work to do, so we want urgently one new director, additional director we want. So board directors can appoint additional director. Now, for how long this guy will continue his tenure? Until the annual general meeting. In the AGM, shareholders will have 2 options, either to appoint him or to remove him. Okay? Chalo. Now, who can get elected as an additional director? Anyone who has not been rejected by the shareholders in the AGM. Always remember that. If you have been rejected by a shareholder in the AGM to stand as a director, you cannot be appointed as an additional director. And AOA must allow appointment of additional director. Tenure is, guys, until the next annual general meeting or the last date where the AGM shall have been held. Okay. So AGM, if it is not been held, last date will be the last date of the tenure. So until the next AGM, he will hold his office as an additional director. If the AGM was not conducted, you have to find out the last date on which AGM should have been conducted. Whichever is earlier will be the date of his resignation. If no AGM, last date when the AGM should have been held. Private companies, it is applicable. Compliance requirement is very simple. You have to file DR12 with the ROC. We all know whenever you're going to appoint a director in a company, company has to file DR12 with the ROC within 30 days. Now in that DR12 form, you will have to affix BR, board resolution, consent, DR2. Remember, guys, KYC and disclosure of interest. What is the meaning of disclosure of interest? If I am a director in many companies, I'm going to get appointed in a new company as a director. I have to tell them that I am a director in XYZ number of companies. These are the names. All the details you have to give it to them. Okay. Next is, guys, alternate director, section 161, subsection 2. So, if a director is absent from India for less than 3 months, in that case, guys, the director can appoint some other person as an alternate director in his place. It's a substitute director. Okay. We will maximize it, zoom in. So meaning, if a person has been appointed to act on behalf of a director and the director is absent from India for less than 3 months, alternate director can be appointed. When can the alternate director be appointed? If AOA allows, guys, or in a general meeting, you can be appointed as an alternate director. Who cannot be appointed, guys? Someone who is already an alternate director. He cannot become a substitute, obviously. If someone is already a director in the same company, obviously he cannot become an alternate director. Are you able to understand the difference between the two situations? In situation number 1, this guy is already a substitute of Ronaldo. Now, how can he be the substitute of another player in the club? In this case, guys, Ronaldo is already playing. How can Ronaldo act as substitute? That is the difference. Okay, guys, I will not explain you more because you will get confused then. Next is, guys, method of appointment, board resolution, including resolution by circulation. Alternate director can be appointed. Okay. Now, what is the tenure of the alternate director? Cannot exceed the OG, means what? Original director's term. So, if I am the substitute of a player, I can be a player until that original person is a player in the game. So, whatever is the original director's tenure or term, for that term and tenure only I can become an alternator, not more than that. Next is automatic reappointment. Applies to original director and not alternate director. So if original director is getting reappointed, it is fine. That does not mean that alternate director is also getting reappointed. There is a difference. Okay, guys. Independence requirement. If the original director is independent, alternate director shall also be independent. This is pure logic, guys. Next is directorship will be counted towards total directorship. I told you a director can be a director in maximum 20 companies. If you are an alternate director, you will still be counted in the 20 companies limit. Applicability. All the public companies and private companies, it is applicable. Next is listed company restrictions. They cannot appoint alternate director for independent director. So if you are an independent director of a listed company, nobody can be your alternate director. Okay. When will the office cease? Original director dies or vacates office, the alternate director's office will also get over, or the OG director returns to India. Purpose is solved. That's it, guys. Chalo. Next is nominee director. Now, guys, what exactly is the meaning of a nominee director? Supposing a bank has given a loan to a company. 100 crores loan a bank has given to the company. Now, bank is afraid if the company is going to manage the funds very well or not. Company will take the right decisions or not. So, bank will appoint one person or a representative in the company to act as a nominee director. To act as a nominee director. Let's read this, guys. So, appointed by the institution, government, or by an agreement by a bank or any other company that is giving loan to represent their interest in the company in which they are giving a loan. Is it allowed everywhere? If AOA permits, IFS a company exceptions. Okay. Rights and power of a nominee director. He is not liable to retire by rotation. Hold office at the pleasure of nominating agency. So, bank can remove the nominating director anytime, whenever they wish. Cannot be removed by the company itself except for the nominating agency. So, guys, only nominating agency can remove the director. Okay. Over here, guys, exception is by or also company can remove nominee director. But guys, such difficult question will not be asked. Appointment procedure, guys. Additional director by the board or as a director other than retiring director, he can be appointed as a nominee director. So there are 5 directors. Now we want to appoint a nominee director. He can be appointed as an additional director. Number 1. Or additional director, we all know who appoints additional director. Board of directors appoint additional director. Or he can also be appointed by the shareholders in the annual general meeting. Okay. Can have a clause in the agreement to appoint or terminate at will. So the bank that is giving loan can have a clause saying that we can remove or appoint a nominator at our will. If AOA does not allows you, you can alter AOA to appoint a nominee director. Nominee director is not considered as an independent director, obviously. That's it, guys. Very easy, no? Are you able to understand every single thing? Can I get a quick thumbs up, everyone? Jayanand, are you able to understand, buddy? Can I get a quick thumbs up? Perfect, perfect, perfect. Next is, guys, casual vacancy. What is the meaning of casual vacancy? Whenever there is a vacancy before the original term of the director, it is called as casual vacancy. Original director has died, he has retired, he has resigned, then casual vacancy arises. So vacancy before the normal expiry is called as casual vacancy. Who fills the casual vacancy? Board of directors fill the casual vacancy. Members approval, is it required? Yes, at the immediate general meeting, members approval is required. How long does the appointee hold office? Until the OG director's tenure. Simple, guys. I am supposed to hold my office as a director for 5 years in the company. Within 3 years, I have resigned. So to fill the casual vacancy, I can be appointed, some other person can be appointed in my place till my term ends. 3 years I served, 2 years are remaining. For 2 years, this person can serve as a director in my place. After that, again, if shareholders want this director to continue, they can appoint him, otherwise they can remove him. Vacancy caused by board of directors. Guys, this is not important, but still I will teach you very, very beautiful topic. Vacancy caused by board of directors appointed director. Now you tell me, guys, which type of director is appointed by the board of directors? Additional director and alternate director. So if additional director or alternate director is appointed by the board and that person resigns, that person dies, in that case, guys, it cannot be filled by board. Otherwise, it will keep on changing. Are you able to understand? Simple. Board directors appoint additional director and then in the AGM, shareholders will ratify the decision. The same way, alternate director is appointed by the board until the AGM. In the AGM, they will appoint or they will remove. So board directors have appointed an additional director. Now this director himself has quit. Shareholders have not approved him in the AGM. To conduct an AGM, there's a long time. I will give you one example, guys. It is not important, but still I want to tell you this. Oh. So, casual vacancy arose. This is the AGM. So between this period, BOD can appoint a director to fill that casual vacancy. Now that director can hold office till the AGM. In the AGM, shareholders will appoint or remove him. Can we say that this director can hold office until the AGM? Yes. But the problem is, this director has also resigned. In that case, guys, board will have to wait until the AGM. They cannot appoint another director. Otherwise, it will keep on changing continuously. Okay? Chalo, we'll move to the main topic, guys. Next is section 164, very, very important section. Disqualification of directors. When can we say that a director is disqualified? When can we say that a director will be disqualified? Hello, Varun. Section 164 talks about when can a director will be disqualified. So guys, don't get scared by looking at the mind map. It is very easy. If a director is of unsound mind, I will zoom in. If a director is of unsound mind, if he is undischarged insolvent, if insolvency case is pending against him, if he is convicted or imprisoned, but over here is the condition, if he is convicted for more than 6 months plus 5 years have not elapsed until his release. What is the meaning of this, sir? Supposing I slapped a guy, okay, I was sent to imprisonment for 7 months, no problem till here. After I am released, 5 years should get over. After 5 years only I can be appointed as a director. Are you able to understand? So until 5 years after release, I am a disqualified director. Simple, guys. I will tell you one thing. Let's say 2026, I slapped the guy. I was sent to imprisonment till 2026 June. On Jan, I slapped the guy. Court said that I will be released on, let's say, the December. Okay, December. So December 2026, I will be released. So after I am released, guys, for 5 years, I cannot be a director. For 5 years after I am released, I cannot be a director. After 5 years, I can be a director. But there is an exception again. If I am convicted for imprisonment more than 7 years or equal to 7 years, I am permanently disqualified. It's a serious offense. So I am permanently disqualified. Next is court or tribunal has disqualified me. Obviously again, imprisonment at least 6 months. Okay, this one is done. Next is, guys, if I am a director, I am supposed to pay the call application money on time. I have not paid call application money on time and it was pending for 6 or more months. Unpaid calls on shares individually or jointly. I can have a joint share also. Individually or jointly, I did not pay the call money even though multiple times it was called and it was unpaid for 6 months. Then I have committed a very serious offense. Being a director, I should not do default in this. Yes or no, guys? So if I have done a default, I cannot be a director. I am disqualified under section 164. Next is, guys, RPT offenses in the last 5 years. So if I have entered into a RPT transactions and I have violated section 188 that talks about RPT transactions, I will be disqualified. So if I have entered into RPT transactions in the last 5 years, I will be disqualified. So I have to wait for basically 5 years for that offense to get over. Okay. Next is, guys, non-compliance with section 165 that talks about number of directorship. I was holding a directorship in 25 companies. That means not allowed. I have contravened the provisions, so I am disqualified. Next is non-compliance with section 152 that talks about DIN requirements. That's it, guys. Now, let's talk about this topic. MCA action. Disqualified directors. If I am associated with any disqualified director and the name has been struck off by the ROC. Why? Because company has failed to file annual financial statements for 3 consecutive years, I will be disqualified. If I am a director, if I was a director in any company, I was the right person, but the company did not file annual financial statements for 3 consecutive years. ROC has completely removed the name of the company. I cannot be a director. I am disqualified even if I did not do anything wrong. Understood, guys? Hi, Suman. How are you? I'm doing great, Suman. Guys, are you able to understand every single thing? Please print my mind map, revise my mind map, learn from my mind map. Very, very important. Next is, guys, private company disqualification. Private company can add additional disqualification to make the law of section 164 more stricter. Company defaults. If a director is disqualified for 5 years, why? Because company has failed to file financial returns and annual statements, financial returns or annual returns for 3 consecutive years. Company has not repaid deposits, interest, debentures, deposits for more than 1 year. So, guys, listen to me very, very carefully. Over here, grace period. So, I am a new director. I am going to get appointed as a director in a Reliance company. Nothing wrong I have done. But Reliance company has not filed financial statements, annual returns for 3 consecutive years. Reliance has not repaid deposits, interest, debentures, dividend for 1 year or more. Now I am going to get appointed as a director in Reliance. So law says I have got 6 months time in the defaulting company. Once I become a director in the defaulting company, I have got 6 months time. In those 6 months time, I have got 2 options. Either to correct all the defaults or to resign from the company. If I am associated with company for more than 6 months, that is doing these defaults, I am automatically disqualified under section 164. Are you able to understand, guys? So I have done nothing, but I am going to be a part of a defaulting company. Law says you have got 6 months time. You either rectify all the defaults or you resign from the company. Everything you have to do in 6 months. If you are a part of a defaulting company for more than 6 months, you cannot be a director in any company. You are disqualified under section 164. Okay? Now, listen to me very, very carefully. The company in which I am going to become a director, directors have been disqualified for 5 years. So company is in a bad mess. Directors have been disqualified. Company has done default. Company has not filed financial statements. I am going to be a part of this company. I've got 6 months time. You either rectify the default or you resign from the company. If you are a part of this company for more than 6 months, 164, you will be disqualified. That's it, guys. Very easy. See, company ABC, defaulting company, not filed annual returns for 3 years. Mr. Raj appointed as a director on 1st July 25. From 1st July 25 to 31st December 25. By 31st July 25, company still has not corrected defaults. Raj will also get disqualified. In my mind maps, you will find all my notes, guys. Okay? Chalo. So let's take a break of, guys. 5 minutes break we will take. Otherwise, you will find it very monotonous. Jayanand, Suman, Varun, everyone, guys, can we take a break of 5 minutes? (6:51 p.m.) Break. Yes, guys. Let's begin. Let's continue. Let's continue. Let's continue. Chalo. Where were we? Guys, I will tell you how many topics are remaining. 167 is remaining, 168, 203, board powers, 180, 184, 196, 197. That's it. Okay? The next half an hour will be done with the topics. Cool, guys? Chalo. I will proceed forward. Vacation of office. So, under what cases office of a director can be vacated? It can be disqualification, it can be death, it could be resignation. Okay. Circumstances that will lead to vacation of office. Director has been removed, office will be vacated. Incurs disqualification, office will be vacated. But there is a beautiful rule to this. Online people, I want you to tell me. One second, I will remove this mess. Yes, guys. So, removal of director is done. Number 2 is, you incur a disqualification under section 164. Your office will be vacated in all the companies that you were a director except for the company where you did your default. You are a director in company A, company B, company C, company D. Okay, allowed limit is 20, so you can be director in 4 companies. Nothing is wrong with company A, C and D. Everything is going perfectly fine, but you did a default in company B. Your office will be vacated. Listen to me very, very carefully. You will stay the director in company B, but your office will be vacated in company A, company C and company D. That means what? In the company in which you did default, you will stay director in that company. But apart from that company, in all the companies, you have to vacate your office. Sir, what kind of logic is this? Why this rule has been made? In fact, in the defaulting company, he should resign. Other companies he can stay, but why the law is saying otherwise? Law is saying that in the defaulting company he has to stay director, but in other companies he has to vacate his office. The logic is simple. If you have made a mess in the company, you have to rectify that mess. You have to rectify the mess and then you can leave. You have done the mess. You cannot be given the freedom to leave the company so easily. Yes, the punishment for you is you have to resign from all the companies except for this company. Why? Because over here you have to rectify your default and then you can leave. This is why, guys, such beautiful laws has been made under Companies Act. Next is absent from board meeting for consecutive 12 months. You are a board member, you have to participate in the meeting, but you are absent for 12 months with or without leave, doesn't matter at all. You have to vacate your office. Guys, there is a difference between vacation of office and disqualification. Disqualification means what? You cannot be a director in any company. Vacation means what? In that company you can not be a director. You have to vacate your office. Conflict of interest. So, I am a director, company is going to enter into a contract with my brother. I have to disclose in the board meeting that he is my brother. So, whatever I will tell will be considered as bias judgment, but I did not disclose to anyone that he is my brother. So, company can deal with him. Whatever I will tell, the members will listen to me, but they don't know that I am his brother. If I did that, guys, I have to vacate my office. Enters into a contract arrangement directly or indirectly interested, it is in contravention of law. Next is failure to disclose interest. So I told you guys, the moment I become a director in any company, I have to disclose to all the companies saying that I have become a director of this company. Everybody should know. But I did not make any disclosure. I have to vacate my office. Fails to disclose interest in any contract arrangement as per section 184, I have to vacate my office. Next is, I am a director in a company. I stop to hold office because I am holding office. Guys, listen. Before we read this, I will tell you one situation. Flipkart, Myntra. Myntra is the subsidiary of Flipkart. Yes or no, guys? I am a director in Flipkart. I am a director in Flipkart. Because I am a director in Flipkart, company says that you also please become a director of Myntra also. Was I independently appointed as a director in Myntra? No. I was appointed in Myntra. Why? Because in Flipkart I am a director. That is why I have been appointed as a director in Myntra. So law says the moment you stop to hold office in Flipkart, automatically you also have to stop holding office in Myntra. This is the logic. Are you able to understand? Yes, Janan, I'm going to come to that point. Don't worry. See, Janan, over here they're going to understand appeal and disqualification. Okay? Chalo. We will move from right to left. So guys, this point is clear. I hold to hold such office as a director due to I stopped to hold office in holding subsidiary associate company. Okay. Next is, guys, court becomes disqualified by court or tribunal's order. I have to immediately vacate the office. Tribunal has told me that you are disqualified. I have to immediately vacate the office. Next is conviction. If I am convicted or sentenced for more than 6 months imprisonment, I have to vacate the office. Obvious, guys. Now this is the another beautiful law that has been made. So if I talk about 5 and 6, conviction of offense, court, tribunal disqualification, law says that immediately our office will not be vacated. There is a possibility that fake complaint has been filed against you. Yes or no, guys? So in that case, guys, if court or tribunal has disqualified me or I have been convicted of an offense, I have got 30 days time to appeal against the order. If I have appealed against the order, now read this very, very carefully. Office does not vacate immediately on 5 and 6. This is 5, this is 6 and this is 5. 30 days from conviction or disqualification, I have to file an appeal. Office will still continue until 7 days after disposal. So until the appeal has been disposed, another 7 days time I have got. I have been convicted on 1st January 26. I have got 30 days time. 31st Jan 26. Until this period, I have to first of all file an appeal. If I have filed an appeal, then I can hold my office as a director. So let's say on 31st March 26, case has been disposed of. Case has been disposed of. 7 days, that is 7th April 26. So I can hold office until 7 days after the appeal has been disposed. Okay? This is situation number 1. Till here, guys, do you have any problem? It is very clear now. I have been convicted on 1st January 26. I have time till 30 days to file an appeal. If I have filed an appeal and the case has been disposed of on 31st March, 7 days, 7th April, until 7th April I will hold an office. After 7th April I have to vacate. But if I have again filed an appeal if I have further filed an appeal, again office continues until disposal. Why? Because a director shall not vacate his office just because of a fake complaint, of a false complaint, of a frivolous complaint. Understood, guys? If the director has appealed, that means he is a genuine person. So law says that no, let the case get disposed of. We'll wait for 7 more days. If he is again filing an appeal, let him stay in the company. Perfect, guys. Chalo. So vacation of office section 167 is done. Now let's see, guys, if the office of a director has been vacated, you know which form is supposed to be filed. DIR 12 form is supposed to be filed. Appointment, resignation, we have to file DIR 12 form. If all directors, there is a very unique situation, if all directors of a company vacate at once, then who is the director? Nobody is the director. In that case, guys, promoter can become a director. But if promoter is also absent, in that case, guys, central government will appoint a director till the company appoints further directors in their annual general meeting. First of all supposing, let's say, there are 4 directors in a company, they're going by car, they met with an accident, everyone died. There is no promoter also. In that case, guys, central government will appoint directors until the annual general meeting. In the AGM, they will appoint new shareholders. Okay. Next is, guys, private company which is not a subsidiary company of a public company. If articles provide additional grounds for vacation, they have to follow that provision. Penalty for non-compliance will be 1 lakh rupees to 5 lakh rupees. Okay. Suman, in your exam, no, sometimes questions can be asked with respect to procedure for appointment resignation. In that case, just remember this one form, that is DIR 12, appointment removal of directors. Okay. Anything that talks about appointment, vacation, removal, resignation, DIR 12 form is supposed to be filed. Okay, I told you guys, CMA Final law paper is getting difficult by every attempt. I don't want any of my students to lose marks. I have included all the information in the mind maps. Simply learn that, guys. It will hardly take you 2 to 3 hours to learn the entire directors and KMP thoroughly. Okay? Chalo. Next is appointment of KMP, section 203. So, who is required to appoint a KMP? Every listed company, every public company whose paid up capital is 10 crores or more, they have to appoint KMP. Now, mandatory whole-time KMP, MD, CEO, manager or whole-time director, if none, CA, CFO, they all are KMP. Restriction on holding office. Holding office in only one company, exception is subsidiary company. So KMP can hold office in only one company. But the exception is you can also be a KMP in the subsidiary company. You can also become a director, KMP, CS, CFO, CEO, managing director, manager. They can become a director in another company provided board gives the consent. Next is managing director can also be a managing director or a manager of another company provided board passes unanimous approval and prior notices given to all the directors. Very easy, guys. Till here, I hope no problem. Jayanand, I'm only covering all the important topics, Jayanand. If I start covering all the topics now, if it is important, unimportant, so it will take 6 to 7 hours for the marathon to get over. So only the important topics that has come repeatedly in your previous attempts, only those topics I am including. Okay? Otherwise, you have to, I'm going to make a one-shot revision where all the topics are revised. So whatever is important from the exam point of view, only I am including in the marathon. Okay, guys, I wish you were there in my regular lectures, guys. I wish You were there in my regular lectures. In that case, we used to discuss every single provision in detailed manner for 1 hour, half an hour using examples. But guys, this is marathon lecture, no guys. We have to cover all the important topics immediately. I have to save your time also. Cool guys? Chalo. Now, Rule 8A says every private company whose paid up capital is 10 CR or more, they have to appoint a whole-time company secretary. Then, sir, what is the difference between this one and this one? This one talks about KMP. KMP will include MD, CEO, manager, or whole-time director, CS, CFO. But over here, guys, I'm talking about company secretary. I'm talking about myself. So, every private company whose paid up capital is 10 CR or more, they have to appoint a CS. Chairperson restriction. So, same person cannot be a chairperson. Along with the chairperson, he cannot be an MD, CEO or CFO. I am a chairperson of one company. I cannot be the MD. I cannot be the CEO or I cannot be the CFO of the same company, guys. But there is an exception to this. Guys, the logic is simple. I shall not take so much responsibility on my shoulder that it will lead to bad compliance. For that purpose, this law has been made that says that if you are a chairperson, you cannot be the MD, you cannot be the CEO, you cannot be the CFO. But there is an exception to this. Exception is if articles permit, no problem. If company only has got one business, company does not have multiple business, company only has got one business. So in that one business only I am the chairperson, MD, CEO, CFO, no problem. But if it's multiple business, guys, how can I be the chairperson, MD, CEO of all the companies? No. The company has got multiple business and there are separate CEOs for each business to take care of the matter, to take care of the compliance. Then I can be the MD, CEO and CFO of a company that has got multiple business. Listen to me very, very carefully. Company has got only one business. You can be chairperson plus MD, CEO, CFO. Okay. Now, company has got multiple business. So, in multiple business, you cannot be the MD and CEO or CFO. But the law says that if company has got multiple business and in all the companies, there are separate CEOs to take care of that, then you can become the MD, CFO, CEO of one company that has got multiple business. Are you able to understand, guys? Law simply says you cannot take so much responsibility that it will lead to bad compliance. Understood, guys? Everyone? Chalo. So, guys, 3 cases where MD, CEO, CFO, chairperson, he can become a chairperson. Sorry, chairperson can be MD, CEO, CFO. If articles permit, if company only has got one business, company has got multiple businesses, but there are separate CEOs to take care of that, then you can be the chairperson as well as MD, CEO, CFO of that one company. Okay. Chalo guys, now once again, procedure for removal, where is this point? Guys, once again, I will just check where is this point located exactly. Guys, how are you liking the marathon? Are you enjoying? I hope it is helpful. I hope you all are finding it helpful. Thank you so much, guys. You are staying with me for so long. It really means a lot to me. Let me know, guys, are you enjoying these marathon lectures? I'm 100% sure that if you go to my mind maps Nobody can stop you from scoring an exemption. That's for sure. Yes, guys. Removal of director, section 169. So also resignation of directors. Chalo guys, let's read how directors actually resign from a company. First of all, he will give notice that he wants to quit the company. Next is board will acknowledge, board will accept his resignation. Then ROC, we have to inform the ROC also. So company files DR12, we know 30 days, and you have to post on the company's website. Then you have to disclose in the board report also. Mention resignation in the general meetings report also. Then director has to file DR11. Company has to file DR12. But the director has to file DR11 with the ROC within 30 days. Now the important question is, what will be the effective date of his resignation? Date of receiving notice or date specified by director that I resign from XYZ date. So any date that is later will be the date of resignation. So the later date of the two dates will be the date of resignation. Number one is date of receiving notice of resignation or date specified by the directors. Very easy. Okay. Special situations. We know this, guys. If all directors resign simultaneously, what will happen? Liability post resignation. So even if you have been resigned, even if you have resigned from the company, you will still be liable. But you will be only liable for the acts that happened in the tenure in which you were a director. Simple, guys. Offenses committed during the tenure. Next is, guys, removal of director. Section 169. So who has a right to remove a director? So any director can be removed simply by passing an OR, ordinary resolution. Simple. Irrespective of appointment method or articles. Do you remember, guys, I told you even a nominee director can be removed by passing an OR. Independent director, guys, this is a beautiful rule. Independent director, if you want to remove the independent director, if this guy is reappointed for a second term, we know that independent director can be reappointed. He can serve maximum 2 years, 2 terms. So independent director has been reappointed. Then you have to pass an SR, not OR, to remove that person. Why? Because if you are removing the independent director in the second term, that means something wrong is happening in the company. You should have removed it in the first term, but in the second term, you are removing him. That means something wrong is happening in the company. Okay. But provided he must be given a reasonable opportunity to be heard. Exception, guys. Okay. Removal provisions don't apply if 2/3 directors are appointed using proportional representation. So only few directors have the power, only few shareholders have the power to appoint a director. So only they can remove them, not other shareholders. Guys, what is the meaning of proportional representation? Simply certain number of shareholders have the power to appoint a director to represent their interest. So if we want to remove them, only these people can remove, obviously. So next is, guys, this one is done. Removal by NCLT, section 242 subsection 2. NCLT may remove director. You have to application of section 241. Guys, do you remember prevention of operation mismanagement? If you are removing a director, NCLT is removing a director because of operation mismanagement, special notice shall be given by the member proposing the removal. Inform the director. You have to send the copy of notice immediately. Then you have to pass a BR to call a general meeting. Then you have to pass general meeting. Now you know 21 days clear notice shall be given to conduct general meeting. You have to include special notice that we want to remove this director. Why do you want to remove this director? And OR is required to remove him. Also include the director's representation. Ask him if he has got anything to say. Right to be heard. And then you have to update the register, public notice. If it's a listed company, guys, you have to inform the stock exchange, forward the proceedings, passing over a general meeting, filing with the ROC DI12, we all know this. That's it, guys. Updating register and public notice that yes, this guy has been removed from the directorship. Very easy, guys. I know that right now you might find it a little difficult to remember it, but it's very easy, guys. Simple. Special notice given by the shareholder, then director shall be informed, then BR has to be passed to conduct general meeting. In the general meeting, OR is supposed to be passed, director is supposed to be given the right to be heard. Then once OR has been passed, you have to file DI12 with the ROC, you have to update the register, and if public notice is required, you serve the public notice. That's it, guys. Okay, let's come over here. Now, guys, section 179. Shall we take a break of 5 minutes? So, 7:23 p.m. we are going to meet. Break. Yes, people. Hello, guys. Yes, Suman, remuneration is covered. Chalo, guys. Let's continue. Let me check once again. Yes, 197 is covered. Chalo, guys. Next beautiful section is section 179 that talks about the powers of the board of directors. So guys, board of directors have got certain powers. Yes or no, guys? Once again, I will remove this. I don't want this. Perfect. So board of directors are given certain powers. They enjoy certain powers given by Companies Act. Now let's read this. Board can exercise all the powers of the company that has been included in the Companies Act, MOA, AOA. Guys, I hope my writing is clear. Shall I zoom in? Yes. So, board can exercise all the powers mentioned in the Companies Act, MOA, AOA, and if shareholders have given powers, they have the right to also exercise those powers. So tell me, guys, tell me 3 sources from where BOD will enjoy their powers. Number 1 is Companies Act, number 2 is MOA, AOA, and number 3 is General Meeting. Now always remember, shareholders cannot give powers more than the MOA, AOA or the Companies Act 2013. Always remember this. Companies Act will come first, then MOA, AOA, and then shareholders. Okay, sir. Now, guys, certain matters are reserved to be decided by the shareholders in the general meeting. It cannot be decided by the board of directors in the board meeting. Companies Act says so. So exception is reserved for shareholders in general meeting. Those matters cannot be decided by the board of directors. Okay. Next is, guys, very, very important. Any regulation passed by shareholder cannot any regulation passed by shareholders cannot invalidate the acts already validly done by the board. Sir, what is the meaning of this? Supposing Companies Act says that you can borrow money up to 100 crores. Companies Act says so. Director has borrowed 50 crores. AOA says that director can borrow up to 60 crores. So director has complied with all the provisions. Now what is happening is, shareholders in their special resolution, they have added a rule that says director cannot borrow money more than 30 crores. Directors cannot borrow money more than 30 crores. Now, does that mean that previous act of the directors are wrong? No. Are you able to understand, guys? Simple. So, any regulation passed by shareholders cannot invalidate the acts that has been validly done by the board. Over here, BOD has complied with Companies Act, BOD has complied with AOA, so no problem. After that, if shareholders pass some other regulation, it will be applied from the prospective effect, not retrospective effect. Past actions will not be invalid, but future actions can be invalid if they take such decisions. Okay, sir. Now, powers that can be exercised only in the board meetings. Certain powers can only be exercised in the board meetings. Number 1 is, guys, making a political contribution. Board can exercise those powers in the board meeting. Calls on shareholders allowed. Appoint, removing KMP allowed. Granting loans, guaranteeing securities allowed. Authorized buyback allowed. Issuing securities including debentures, domestic, foreign allowed. Approving financial statements plus board report allowed. Diversify the business allowed. Borrow money allowed. Investing funds allowed. Approving amalgamation, merger, any type of reconstruction allowed. Takeover, acquiring, controlling stake or a significant stake. 20% over here is 60%, 51% allowed. Appoint internal auditors plus secretary auditors completely allowed. Now, sir, what is not allowed? We're going to understand over here. Section 180, restrictions on powers. Okay. Now, guys, board of directors can also delegate their powers. BOD can also delegate the powers to some committee of directors. Example, CSR committee has the power to take decisions with respect to CSR. NRC committee has the power to take decisions with respect to NRC. So, board of directors can delegate their powers, transfer the power to take decisions to any committee, to a managing director or manager, to any principal officer, or to any branch officers. Yes, to any branch officers where principal officer will take the decision. This we know. So the crux is board of directors can delegate their powers to take decisions to these people. Now exactly how can you delegate the powers? Are you supposed to pass a BR or these powers can be delegated via circular resolution? So delegable powers. First of all, let's understand what powers can be delegated. We know to whom we can delegate. What powers can we delegate? We are going to understand. Borrow money, we can delegate. Investing companies fund, we can delegate. Granting loans, give guarantees, provide securities to the loans, we can delegate these powers. Now guys, the most important rule is while you are delegating these powers, you have to pass a BR. You have to pass a BR. Now the BR can be passed in a board meeting or it can be passed in resolution via circulation. So law says you cannot delegate these powers via circulation. You have to delegate these powers in the board meeting only via board resolution. Circular resolution is not allowed. Are you able to understand, guys? Now every single thing is clear. Very easy. So just learn my mind maps. You are done, sorted. Banking companies, these provisions will not be applicable. Acceptance of deposits, borrowing by bank, arrangements, they are ordinary course of business itself doing these things. Okay. Exceptions. Section 8 company and IFSC company can give power to borrow, invest, grant loans via circular resolution. So Section 8 company, it's completely fine. IFSC company, it's completely fine. Sir, what is the meaning of IFSC company? IFSC companies are those companies whose 99.99% transactions are foreign transactions. So they bring in lot of money. That is why government gives them a lot of benefits. Their time zones, the way they manage things are completely different from a normal Indian company. Are you able to understand, guys? Very easy. Chalo. So this is done, guys. This is done. Now let's talk about section 180. We know the powers of the board. Now we're going to understand the restrictions on powers of the board. Board cannot exercise certain powers without passing a special resolution by the shareholders. Board cannot exercise certain powers without prior approval of shareholders. Over here, they don't require prior approval of shareholders, but over here, guys, they require prior approval of shareholders only with respect to certain matters. What are those certain matters, guys? Simple. Borrowing beyond the limits. If you are borrowing money beyond the limits mentioned in section 186, you have to obtain shareholders' consent via special resolution. Limit must be specified clearly. If banking company, if their ordinary job is to accept deposits, no problem. Then temporary loans. What is the meaning of temporary loans? Short-term loans or cash credit, repayable on demand, less than 6 months, do not count. People, this is not important. Just understand, if the board borrows money beyond the limits, they have to pass a special resolution. Next is invest in the compensation received from merger amalgamation. So company got merged, company got amalgamated. Okay. So after this process, during this process, because of this process, company received some money. Now company received this money, they cannot invest this money without the approval of shareholders. Merger, amalgamation, you receive some money, you cannot invest this money without the approval of the shareholders. You require special resolution. Next is, guys, sale, lease, disposal of undertaking. Now, sir, what is the meaning of undertaking? Undertaking means, guys, any business or project that has investment more than 20% of company's net worth. It's called as undertaking. Or that business or project generates 20% or more of the total income. That is called as any business or project. So company cannot sell, lease or dispose of the undertaking. Why? Because it's a very important asset, whole or substantially whole, without the approval of shareholders via special resolution. Next is, guys, if you are going to increase the tenure of the loan of the director, company has given loan to a director. Company has given a loan to a director by passing a special resolution. Now, board of directors cannot extend the tenure of the loan without the approval of shareholders. Easy now, guys. Shareholders' approval is required to give time to remit the payment of any debt due from a director. Exception, guys. So 180 exceptions is, if I have entered into a transaction in good faith where director has not complied with section 180, I will not be penalized. So if I am a buyer or a lessee, I have entered into a transaction in good faith, my actions will not be invalidated. My actions will be valid. Next is, guys, next condition is, provided sale and lease of property is in the ordinary course of business. Company's ordinary course of business is sale and lease. So while they were transacting, they gave this land to me on a lease. Now I did not know that directors do not have power. So guys, I will still enjoy all the benefits because I am a good faith person. I entered into a transaction in a good terms, good faith. I did not know the directors were acting beyond their powers. Why? Because company's ordinary course of business itself, selling and leasing land. Are you able to understand, guys? Very easy. Chalo. Let's proceed forward, guys. Section 184 simply says disclosure by interest of the directors. Simple, guys. I told you example. Do you remember? Company is dealing with my brother, but I did not tell the company that he is my brother. I confidently participated in the board meeting. I gave my inputs in favor of my brother. That means I was not acting in the best interest of the company. Yes or no? That means what? I have violated section 184. So, disclosure of interest. What to disclose? I will just zoom in this. Disclosure of interest. So, what to disclose, guys? Any concern or interest in the company, in the body corporate, in firms or any other association of individuals. If I am associated with any company, individual, association of individuals, firms, body corporate, company, I have to immediately inform this company that I am also a shareholder of this company. I am also a director in this company. Immediately I have to disclose. Now exactly what to disclose? Shareholding in such entities I have to disclose immediately. Now whatever notices I have served, in that notice I will tell everyone that I am a director in this company, I am a shareholder in this company. Now that notices shall be kept at RO, preserved for 8 years. It should be kept in the custody of a company secretary or any other person. Okay, sir. Now, when do you have to make disclosure? We understood what to disclose and we also understood what contains, okay, one second guys. Yes, we understood meaning of disclosure. We also understood what to disclose. Now we're going to understand when to disclose. At the first board meeting in which the director participates, post appointment, I have to immediately disclose that I am a shareholder. Simple guys. I am a director of Reliance. I became a shareholder of Adani also. Immediately in the next board meeting of Reliance, I have to disclose that I am a shareholder of Adani also, or I am a director of Adani. Next is guys, first board meeting of every year, irrespective of any changes are there or not, every year I have to make disclosure of my interest. Then guys, whenever any change previously disclosed interest, disclosure should be in the first board meeting. Simple guys. Whenever there is any change, supposing I was holding 10% shares in Adani, now I am holding 12% shares. Immediately in the next board meeting, I have to tell that now I am holding 12% shareholders. Sorry, 12% shareholding guys. Simple. Earlier I was holding 10% shares in Adani. Now that shareholding has changed to 12%. Immediately I have to disclose that now I am holding 12% in the next board meeting. So the moment I started to hold shares in the Adani, immediately in the next board meeting I have to disclose. Number one, every year's first board meeting I have to disclose. And number three, whenever there is any change, I have to disclose in the subsequent board meeting. Okay, sir. Now, if you don't make disclosure, without disclosure, and you participate in the meeting where you did not disclose that I am his brother, the contract that the company has entered into with my brother can be cancelled at the option of the company. Simple now guys, because that contract will not make any sense. Why? Because I have told many things in my brother's favor. Company does not know that I am his brother. That means contract can be voidable at the option of the company. Simple. Penalties guys, director contravening will be liable 1 lakh fine. Okay. Now, made or proposed with. So guys, disclosure of interest, disclosure of contract or arrangement that has been entered into by a director with a company, where in that company director along with the others hold more than 2% shares, or I am a promoter, manager, CEO of a body corporate, I have to disclose obviously. Or if I am a director, if I have entered into a contract arrangement with a firm or an entity in which I am a promoter, owner or member, I have to make disclosure. Easy now guys. Rules: disclosure must be made in the first board meeting. Contract arrangement must be discussed. Disclosure must be made in the first board meeting where contract or arrangement were discussed. And I, who is an interested director, shall not participate in the discussion or the voting. Okay, sir. How should the directors disclose their interest? Form NDP 1 includes shareholders in those entities also. That form also includes shareholding in those entities. Okay, sir. Varun, Jayanand, Suman, guys, everyone, are you with me? Can I get a quick thumbs up? Guys, I hope you are paying attention. Give me a quick thumbs up, guys. Chalo guys. So these exceptions are not important, but still we will read this. Other laws apart from companies that can also add additional conditions. Minor shareholding less than 2% of paid share capital will not be counted in the 184 interest. So if I have invested 1% shares, I don't have to make disclosure. 2% or more, I have to make disclosure. Private company, if I'm talking about private company, interested director can participate. Then that's it, guys. Till here only you have to study. We'll quickly wrap it up. If a director becomes interested post contract, he must disclose. So, one person company has entered into a contract with. Earlier he was not my friend, but after company has entered into a contract with this guy, I became his friend. Coincidentally, I have to immediately disclose that this guy has become my friend. So you should know this. Okay, chalo guys. Now comes section 196, appointment of managing director, whole time director, manager. So guys, another 15 minutes and then we will be done with the lecture. Okay, chalo guys. So restriction is no person can be a manager or a managing director at the same time. Tenure is maximum 5 years. Tenure is the tenure of managing director or manager. Reappointment allowed within 1 year before expiry of current term. So if my term is going to get expired, so 1 year before I have to be reappointed. Okay. Disqualification, managing director, whole time director, manager cannot become the managing director, whole time director, manager if my age is less than 21 years or if my age is more than 70 years. But exception is special resolution allows me to do that. Okay. Insolvent, enter into a compromise with the creditors, not allowed. Convicted for equal to or more than 6 months jail, not allowed. SR not passed or can be passed, but you take the approval of central government, then it's valid. Then guys, approval step simple: board approval, shareholders approval, central government's approval. If Schedule 5 conditions are not met. Sir, what is Schedule 5 conditions? All these small conditions are Schedule 5 conditions. He should be resident in India. His age should be between 21 to 70 years. Not fined more than 1,000 rupees or convicted for listed companies acts. He shall not be detained under COFE POSA Act. It's something drugs with respect to offences or FEMA with respect to offences. That's it, guys. With central government's approval. So if Schedule 5 conditions are not met, I have to obtain the approval of central government. Then you have to apply MR2 within 90 days. You don't have to remember this form, guys. Just read this. If very difficult question is asked, you should be able to answer this from this mind map. Very easy, guys. Chalo. Next is appointment of managing director, whole time director, manager. Section 196, step-by-step procedure. First, you will pass board meeting. Then you will pass general meeting. You are going to pass OR in that. Central government approval is required. You take that approval. Execute that agreement with the managing director, manager. Update the register. You have to file MR1 for return of appointment within 60 days. DI 12 have to be filed. We know this. MGT 14 is supposed to be filed for filing of BR. Why? Because this one is important, guys. You are appointing managing director, whole time director, manager. In that case, you have to file BR. Then, guys, attachments are in MR1. What all attachments you will make? BR, shareholders resolution, consent letter, central government's approval, and NRC certificate. So for private companies, government companies, IFSC companies, it is completely exempt. Okay. So guys, let's take a break of 5 minutes. My throat is very dry. We'll take a break of 5 minutes and then we'll resume this. Okay. We will resume at 8:52 p.m. Chalo. Yes, guys, everyone, let's resume. Two topics are remaining and then we are done. Okay? Chalo. Managerial remuneration, very important section 197. That says how much remuneration can you pay to managing director, whole time director, manager, or non-executive directors. Let's read this, guys. So, overall, maximum remuneration that you can pay is 11% of net profit to everyone. Everyone included, maximum you can pay 11% of net profit. Now, this net profit must be calculated using section 198. 198 talks about what all expenses can you include, what all income can you include, what all expenses can you exclude or income can you exclude while you calculate the net profit. Now, based on that net profit, after excluding, including, then you have to find out 11% of net profits. Okay. Now, this remuneration will exclude sitting fees or any money received in professional capacity. Okay. Now let's talk about individual limits. So, if you want to pay to one managing director, manager, or a whole director, maximum is 5%. If we want to pay to more than one MD, manager, whole director, 10% overall you can pay as remuneration. Only one MD, manager, or whole director, maximum 5%. More than one MD, manager, whole director, you can pay maximum 10%. If you want to pay remuneration to non-executive director, two situations will be there. Whole time director, manager, whole time director, MD exist, then 1% of net profits. If whole time director, manager does not exist, 3% of net profits. Very easy, guys. You have to learn this. Okay. All right. If company has done a default, then creditors' prior consent have to be obtained before you pay remuneration. Okay. If no profit or inadequate profit, you have to follow Schedule 5 conditions. Mode of payment, it can be monthly, it can be net profit, or it can be combination of both. Now this one is very, very important, guys. If at all these people have received extra money beyond which they should receive because of some transactions they have entered, they have to refund this money. Why? Because this money belongs to the company, not them. They have to refund this money within 2 years or any shorter period mentioned in the AOA, if any. Until refunded, you cannot use this money as per your whims and fancies. You have to keep this money as a trust. You have to protect this money. Now, waiver of refund. So, it's completely fine even if these directors who have received extra money, they even keep this money, it is completely fine, provided prior consent. Okay, provided special resolution has been passed within 2 years. Number one, if company has done a default, obtain the prior consent of the banks and financial institutions before you waive the refund. Why, guys? Because company has done a default. Company does not have money to pay for the bank. How can they waive the refund? The money does not belong to directors, first of all. How can you ask the directors not to pay us when you have done a default clearly with the bank or financial institution? So obtain their consent. Okay, guys, very easy. That's it. Always remember, guys, net profit is always calculated before deducting managerial remuneration. Net profit, then, guys, you have to always, so net profit is always calculated before deducting managerial remuneration. Obviously, guys, managerial remuneration. Okay, chalo. Now, compensation for loss of office. Till here, Yes, Suman, I think you are going to ask me this question, right? Sir, if any amount due already in the specified period to director as remuneration, can he adjust with it? Suman, we can adjust with it. Yes, completely fine. The next topic is compensation for loss of office. Always remember, guys, whatever money belongs to the company will belong to the company. Whatever money belongs to director can go to the director. If any money extra received by the director, they have to refund it back to the company. If company says no problem, can keep this money, it's completely fine. But if company has taken a loan and they have defaulted that loan, company will have to ask the bank, can I waive the refund or not? Understood, guys? Chalo. Now, next topic is last, compensation for loss of office. Guys, whenever a company gets merged, amalgamated, so one company closes down. If one company closes down, employees may lose their job. Among those employees, director may also sometimes lose their job. So we have to pay money to directors also. So let's understand compensation for loss of office. What is the meaning of this? So due to, one second. So over here, guys, compensation is not allowed. It is not allowed. So, in what cases compensation for loss of office is not allowed, we are going to understand. Number one, guys, due to reconstruction, amalgamation, and director gets similar position, he has not lost a job, but he has been offered a similar job somewhere else, so the director will not get any compensation for loss of office. Director has voluntarily resigned. Why would we give him compensation? He has been removed by the tribunal for disqualification. Obviously, why would we compensate him? Winding up due to negligence or default. So director has done negligent, because of which company was wound up. Director is guilty or for fraud or misconduct. He has caused his own removal. In that case, director will not be given any compensation. Janan, tomorrow will be Pamla, MSME, and Competition Act. Okay. So guys, compensation limit. Now what will be the maximum compensation limit? Remaining terms pay or 3 years pay, whichever is shorter. Remaining terms pay or 3 years pay, whichever is shorter will be the compensation for loss of office. If a director was appointed for 3 years, 2 years is over, so only 1 year he will be payable, whichever is less. If a director has been appointed for 6 years, after 1 year he has resigned, maximum 3 years compensation only we will pay. Okay. If company has been wound up, obviously we cannot give him any compensation in the last 12 months. Okay. That's it, guys. Cannot personally profit from company's operations. So if director has received any benefit while he was holding an office in the company, any extra profit, he has to give it back to the company. That's it, guys. Jayanand, once our marathon gets over, no, then I will start sending you daily MCQs and practice questions. Okay, guys. What's happening is I'm also taking marathon for CSWT. My existing CMA final batch for December attempt is going on, and marathon is also going on. So managing all the things, guys, is a little difficult. So once this marathon gets over, you will definitely receive all the questions. Okay, guys. Chalo. Now, what we are going to do is we are going to quickly solve questions. Three questions, guys, and then we are done. Okay. Chalo, guys. This question is section 187. I have taught you along with section 186. Okay. So always remember, guys, intro, provision, conclusion. That's it. So just read this question because this was the question that has to be covered in the last marathon lecture, guys. Okay, very simple question. Repeated times this question has come in your exam. Section 187, where you're holding investment in another person's name, when it is allowed, when it is not allowed. Do you remember, guys? Section 187, company shall hold investment in their own name. Okay. Next question, guys. I want you to read this. Read this question, guys. I will give you 2 minutes. Wait, guys, wait. Don't go. Don't go, guys. Don't say thanks for your support. Please. 2 more questions are remaining and then you go. Okay. Yes, guys. Let's read this. So, Mr. Jhunjhunwala proposed the name of Mr. Danpat as a director, not liable to double rotation, in Vidha Limited, submitted a notice in writing on 15 July 2024, along with a deposit of 1 lakh rupees. Okay. State the validity of the proposal of Mr. Jhunjhunwala in the following situations. Number 1, if Vidha Limited is a government company, and the government has been duly intimated, then do you think, guys, provisions will be applicable? No. So as per section 161, notice and deposit requirement are required for appointment of director. As per provision 161, the section shall not apply to a government company where the concerned ministry has been intimated. So in this case, guys, Vidha Limited is a government company, government has been duly intimated, so the proposal is valid, and section 160 is not applicable. So government company enjoys exemptions. So obviously section 160 will not be applicable to government companies. Very easy. Okay. Next is, if Vidha Limited has a provision in its articles for election by postal ballot, obviously if articles contain stricter provisions, I have told you they have to follow articles only. Do you remember, guys? See, Vidha Limited is a normal company, hence 160 applies. Notice and deposit requirements have been properly complied with. The articles require election by postal ballot, which must be followed. Conclusion is the proposal is valid, but the appointment must be made through ballot. Okay. Next is, if it's a public limited company. Now it's not a government company, it's a public limited company, and the company has not served individual notices on members, but 7 days before the meeting they have done advertisement in a local vernacular newspaper in a district where the registered office is situated. Is it valid, guys? Think and tell me. It is not valid. Why? As per section 160, where individual notice is not sent, advertisement must be published in 1 English, 1 vernacular, at least 7 days. So they have complied with 1 vernacular and 7 days. They are not complied with English. Hence it is not valid. Easy now, guys. Now last question, I want you to read this question. Very, very important. Many times this question has come in your exam. Read this question, guys, quickly. Yes, guys. Let's start solving this question. Beautiful question, guys. Trust me, if you solve this question on your own, that means you are a genius. Okay? So, Mirinda Limited is an unlisted company with paid up capital of 40 crores and turnover of 350 crores. Guys, I told you, woman director requirement, tell me guys, 300 crores is touched. They have to appoint a woman director. The company has the following top management personnel. Rajiv Mishra, he is a promoter and MD. Preetham, he is a non-executive chairman. Charan Chadda, he is a director in finance. Anurag Sinha, he is a director in operation, but also he is associated with the promoter. Supriti, she is a CS. The company is planning expansion and wants to avail sizable loan from a national bank, because of which the bank has nominated, the bank wants to nominate a director on the board. So company has taken a loan from the bank wants to nominate a director in the board. Is the present board properly constituted? If not, what is a non-compliance? Can Anurag Sinha be considered independent? Simply guys, see, if he is associated, he cannot be. What will be the status of, this one is the most important question. What will be the status of the director nominated by the bank if the said nominated director is a woman? Does that mean that woman director has been complied with? Very, very important question. If a nominated director is a woman director, can we say that company has complied with the woman director requirement? Let's understand. Whether the board is properly constituted or not, guys, tell me. We know every public company having paid up capital 100 crores, turnover 300 crores, requires at least one woman director. They don't have one woman director, non-compliance. Then we know, guys, which public companies have to appoint at least two independent director. Public company having paid up capital of 10 crore or more, turnover 100 crore or more, loans exceeding 50 crore or more, they have to appoint at least two independent directors. So there are no independent director, guys. Nowhere it is mentioned that any director is independent. So it's another non-compliance, guys. Present board does not include women director, independent directors, non-compliance. Whether Anurag Sinha can be independent? No, because he is associated with the promoter. Next is status of nominee director and women director requirement. Now let's read this. Beautiful provision. A director nominated by the bank is called as a nominator. We know this. The law does not exclude nominators from being counted as a woman director. So if bank has appointed a woman director as a nominator, that means woman director has been complied with. Director nominated by the bank will be a nominee director. If the nominee is a woman, she can be counted towards woman director requirement. Conclusion, we know this. Easy now, guys. Are you there with me, everyone? Last question. Requirement of a CFO. I told you guys, CFO will come under KMP. Now tell me, as per section 203, which companies are required to appoint a KMP? Any company whose paid up cap is 10 CR or more, they have to appoint a whole time KMP, including managing director, CEO, CS, CFO. So tell me guys, what is the paid up capital? paid up capital is 40 CR. That means they have to appoint a CFO. So Mirinda has paid up capital 40 CR, hence requirement applies. Conclusion is the company is required to appoint a CFO. That's it, guys. So we are done with our chapter of directors and KMP. How was the session, guys? How was the session? We had a 3-hour long session, guys. Okay? Suman, Jayanand, Varun, guys, it's very difficult to stay with me for 3 hours. You know, normally people can simply watch the lectures at 1.5x speed, 1.25x speed online. That is very convenient and time saving for them. But you have stayed with me, guys. Thank you so much. It really means a lot, guys. Okay? Chalo. So we will end this lecture. Thank you so much for watching. Eat well, sleep well, study well. Take care and bye-bye. I will see you in the next one. Thank you, Suman. Thank you, Jayanand.